Now, it's no more news that the House of Reps has passed the executive bill by President Bola Tinubu to increase the pay of judicial officers nationwide. The bill seeks to amend aspects of the Certain Political, Public and Judicial Officers' Salaries and Allowances Act and could see the salary of the Chief Justice of Nigeria jumping 800% to 64.6 million naira per annum, while other Supreme Court judges will earn 60.47 million naira. This pay rise trickles down to every cadre of the judicial sector. Now, while the move has been commended by stakeholders in the judicial sector, it's been condemned by others outside the sector who thinks it's reward for the roles the judiciary played during the 2023 general elections and for the roles they are expected to play in future elections. But there are also some judges and lawyers who think that the figures being bandied about are not far-reaching enough, especially when one considers that the last time salaries of judicial officers holders was increased was in 2008. They say it's not reasonable considering the state of the economy, the rate of inflation, the rate at which dollar is exchanged to the naira, and that it is even a far cry from what judicial officers in Commonwealth countries earn. Now, this is the starting point of my conversation with senior legal practitioner Jiti Ogunye.
The factors enumerated, namely the exchange rate regime, the rate of inflation, the comparative salaries and emoluments of judges from other Commonwealth countries and common law traditions, and the state of the economy. Yes, these are good reasons to have a realistic fixture this time around. However, we need to stress that just as what was done in 2008 appeared solid, but in no time, proved to be inadequate, what may be fixed now, may also be gutted by inflation, economy, and so on and so forth. So, I call therefore for a systematized increase. And this will be an outcome of a robust debate and not just an offshoot of the weaving of the wand of presidential altruism. And so that will mean that when we conduct that debate, and these critical factors are taken into consideration, we will arrive at a figure that will be put on a grid or table so that as the rate of inflation is swinging like pendulum, these fixtures can be adjusted on the scale. I've called for this before, so that we won't have to come again and again to be adjusting salaries and so on and so forth. For example, if the economy of Nigeria were to improve and the exchange rate were to become more stable, and that, the rate of inflation drops, will anybody be advocating that any salary regime for judicial officers that might have been fixed now should then be revised downward? Will anybody be suggesting that? No, nobody will be suggesting that. That's why we call for a realistic adjustment that will reflect the totality of these factors and which can then move up and down that grid or scale. But beyond that, for those who may just be saying, oh, this is not sufficient, what the president has done is not a reflection of the aspiration of the legal community, lawyers, judicial officers, and all that, who have been drawing attention to this for a long time. We will need to do some kind of contextualization. These judicial officers are Nigerian judicial officers. So what is the state of the Nigerian economy? What is the salary, expectation of professionals? Granted that judicial officers offer a special service to the country, but doctors can also say so. Academics can also say so. Policemen can also say so. Military officers or soldiers can also say so. Indeed, they can say that they put their lives on the line every day and they may be killed. So there can be justification across the sectors, infinitely. Therefore, judicial officers, lawyers must care about Nigeria. They must care about Nigeria, that these adjustments, as desirable as they may be, can only be best guaranteed in a Nigeria that is better, in a Nigeria that is prospering economically, in a Nigeria that is socially stable. And that without this, if you want to now create an island or an oasis of remuneration or remunerative comfort for ourselves because of the special service that we render, there may be a disequilibrium in the system. So we need to think wide and big, and then wish that our country is better than it is.
Still talking about money, I hear what you say about the need to consider the state of the economy as at present, but the bill seeking to stop payment of pensions of former governors and their deputies that are National Assembly members. Some lawyers say that the bill and the debates on it by the National Assembly are unnecessary attempts to usurp the powers of the state houses of assembly to make laws.
For some time now, the salaries and pensions and allowances of former state executives in the country, governor, deputy governor, etc., that matter has been an issue that many are debated. The anger is not only about the humongous nature of these pensions, but also about the double portions of those who may be concerned. Some of them are living at their states and they become federal ministers, they become federal legislators, and they also draw salaries. So they start drawing money from both ends. And then for the former, they draw it till the end of their days for life and all that. I think that this is what actually rankles. And so for me, it's a matter that the National Assembly need to care about. Now, it is true that we run a federation or we run a unitary system masquerading as a federation, depending on how you look at it. But in spite of what we have, under the Constitution, it is within the legislative domain or province of the state to legislate on matters like allowances and remuneration for their respective former political office holders. And so it's a matter that they have to be concerned about. And not just for the optics, but because we are talking about good governance, we are talking about better society. And, it is not right for resources of states to be fleeced, for resources of state to be stolen in the name of, remunerating past office holders. So, it's a concerning matter. And being concerned about it, therefore, they will need to answer some questions. First, this matter that they want to dabble into, do they have the legislative power to dabble into it? They may have the legislative power to dabble into issue of remuneration of federal political office holder, the president, and the exercise powers in that regard. Now, can they have a law of general application? What does the Constitution say? And all that. Yes, they have the power to legislate for the entire country. What is in doubt is whether they have the power to legislate specifically for a state, thereby attempting, as it were, allegedly to usurp the powers of the state's House of Assembly. I will cite a case for a guide. And that case is the case of Attorney General of Ondo State and Attorney General of the Federation in 2002. The first legislation that the Obasanjo administration supported was the ICPC Act. And that act was passed. But state executives were challenging the constitutionality of that law. And the argument was that corrupt practices or corruption is not covered by the exclusive legislative list. It's like a criminal offense to be defined in the criminal code of every state, and therefore the federal government should not legislate on it. And the matter went to the Supreme Court, and the Supreme Court held in that case that corruption has become a national malaise. It has become a national problem. So much so that the Constitution referenced it in Section 15(5), when it provides that the state shall abolish all corrupt practices and abuse of power. And that being so, the National Assembly, for good reason, can legislate for the entire country. And so that law was saved. It was not struck down. And the law continued to operate. And it was thereafter the EFCC Act also came. And the EFCC also had similar challenges. Therefore, I think that the issue of remuneration of past political office holder across the country by state government haven't become a major issue in Nigeria, which is very concerning. The National Assembly as a whole, in my view, may look at it and create a kind of norm, and then answer the question whether it is indeed desirable to remunerate past political office holder. I don't think so, because they are not career public servants who are entitled to pension. Somebody came to office and spent 4 years as a political office holder. So what are you giving him pension for? For life. What are you giving him pension for? And many of them are still very active. Inevitably, when they become governor, they want to become president. When they become governor, they want to become senators and so on. So why do you then need to remunerate them? I think that the National Assembly, in discussing this matter or in making an enactment, must not just face one way. The National Assembly can legislate. It's not always for, yes, to prohibit it and say that no, this cannot happen, not at the state level. But I reckon that having tolerated it at the national level, the likelihood is that they want to do something at the state level that will be uniform, But states where the internally generated revenue currently is so paltry, is so poor, certainly, inevitably, may have to have recourse to fact account, federal allocation, to even pay that kind of money that we're talking about. So why do you need to take money from the center and then use it to pay yourselves after you've left office? I think that it's too much a burden for the people to bear at this point.
I hear what you say about corruption, that it has become a national menace, which the court took judicial notice of. But in relation to the question that I asked earlier about judges, does it not make sense that as the country moves to increase the remuneration of judicial officers, we also remove the immunity that they enjoy? That one that says that until they are investigated and removed by the NJC from the bench, they can't be prosecuted for corruption.
That makes a lot of sense, but there's a caveat here. Jumbo pay alone, standing alone, will not insulate judicial officers from engaging in corrupt practices. I mean, there is no empirical data to support such a view. I think that the judiciary, and in particular the Supreme Court, did a great harm to the fight against corrupt practices in the judiciary by giving themselves that decision on immunity. And what was the decision? that for any judicial officer to be investigated and arraigned in court, he must first have been investigated by the National Judicial Council, disciplined, and removed from the bench before you can proceed against him. In their own thinking, they felt that the judiciary would be subjected to untold ridicule if serving judicial officers were to be investigated and arraigned in court. I disagree with them because the law does not say so. The Constitution did not say so. The Criminal Code has provisions for arresting judicial officers. It's there until that decision came. And there is no provision of the Constitution outside the provision on immunity, Section 305, on immunity for president, vice president, governor, deputy governor. Judicial officers, in Nigeria didn't have such an immunity. So what the Supreme Court did in Nigerian is to do that. Now, having done that, is it advisable to have a legislation to overturn that Supreme Court decision? Some of our colleagues, they say no, that would be disrespecting the judiciary. But look, that decision was a self-serving decision, and the legislature can look at that and say, if all these things are being done and we have judicial officers who are on the radar, okay, just like politically exposed persons, okay, because usually when you are talking about corrupt practices, unless there is a problem in the chain, the giver who is favored by a trial outcome will not talk, and the taker will not squeal. So it's a quid pro quo, and there is silence forever, right? It is difficult to then get the person who is holding the shorter end of the stick, maybe, imagining things, maybe speculating, but he has no hard evidence, he has no proof. And so the anti-corruption agencies can then use technology, modern, investigation devices to eavesdrop. You can't do wiretapping, to pry into accounts of spouses, of children, to look at, lifestyle. Cannot even do that because it's not an offense yet. And it's only when a petition is done, against a judge, that you then have an investigation. Whereas, anti-corruption agencies generally, including the police force, can apprehend criminality. It is basic that it is not when a crime is committed first that you can apprehend it while that crime is being committed. So in this case, it is said that you must first file a petition. So if no petition is filed, nothing happens, and the game goes on. There's a problem with that.